Hello friends, I hope you all are doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today, we will be discussing the topic of Hindu wife's right to claim separate residence from her husband. Half of the Indian population are women. Throughout the history, women have faced and continue to face discrimination in silence. Self-sacrifice and self-denial are their nobility and fortitude, and yet they have been subjected to all inequalities, indignities, and discrimination. As propounded by Justice K. Ramaswamy in the case of Madhu Kishwar versus State of Bihar, AIR 1996, Volume 5, SEC-125. Marriage is the very foundation of any society. It is sine qua non for family peace and stability. Any family imposes certain rights and obligations on the husband and wife who are important constituents. It is considered a sacred social institution according to Hindu law, where marriage is not a contract but a sanskar or sacrament. Many ancient texts refer to the institution of marriage. According to Mahabharata, a wife is not only a source of dharma, artha and kama but also a source of moksha. The Ramayana states that a husband's very soul is said to be his wife. She is referred to as Grahini, the lady of the house, Sachiva, the wise counselor, and Sakhi, the friend of her husband. In other words, husband and wife are considered the two wheels of a same chariot. The right to maintenance arises from the concept that an undivided family creates the right to maintenance. The head of such family is obligated to care for its members, their wives, and their children. Hindu law creates the liability to maintain the wife, which arises from the legal relationship between the parties. Modern Hindu law generally holds husbands responsible for the maintenance of their wives, both during and after marriage, based on the principles of social welfare and ancient traditions. Section 18 of the Hindu Adoption and Maintenance Act 1956 mandates that a Hindu husband must maintain his wife, whether married before or after the commencement of the act, throughout her lifetime. The doctrine of maintenance to the wife sprang from her matrimonial tie, which obligates the husband to maintain the wife during his lifetime, regardless of his possession of any property. Hindu texts and commentaries enunciate this moral obligation of the husband to maintain his wife as a legal liability. The obligation of the husband is by virtue of marriage. It is personal and arises from the very existence of the relationship between the parties. It's by virtue of marriage. In the case of Jagat Krishna versus Ajit Kumar, AIR 1964, Odisha 75, the husband bears the burden of proving that the wife is not entitled to maintenance. So, moving further, let's discuss the definition of maintenance. The right to obtain reasonable necessities that are reasonable. Section 3, Clause B of the Hindu Adoption and Maintenance Act 1956 defines maintenance. So, according to this section, maintenance includes: first, in all cases, provisions for food, clothing, residence, education, and medical attendance, and treatment. Secondly, in the case of an unmarried daughter, the reasonable expenses of an incident to her marriage. The word Hindu wife in Section 18, Clause 1 of the Hindu Adoption and Maintenance Act 1956 connotes only a legally wedded wife of a Hindu, and such a wife alone is entitled to claim maintenance from her husband under this section. So, if her marriage is void ab initio, she is not entitled to claim maintenance under this section. In this section, Hindu wife refers only to a wife whose marriage is valid under the provisions of the Hindu Marriage Act 1955. The wife whose marriage has been solemnized but is void on the ground that the first wife of the husband is living at the time of marriage is not entitled to claim maintenance under the provisions, as decided in the case of Abiola M. Subba Reddy versus Padmana, AIR 1999, AP 19, also cited as 1999 Volume 1 ICC 753. So, during his lifetime, the right to maintenance is a personal right that cannot be extended against any relatives of the husband, regardless of whether the wife has been abandoned by him. The court observed in the case of Shrimati Tejasvi versus Arvindra Tejas Chandra 2010 that a husband cannot deny maintenance to the wife if she is highly qualified and sacrifices a lucrative career for the sake of her family, and if her husband neglects or refuses to maintain her on the ground that she is highly educated and is capable of earning. That is not sufficient ground to refuse maintenance. So, in today's lecture, we will deal mainly with Section 18, Clause 2 of the Hindu Adoption and Maintenance Act 1956, which lays down 7 grounds on which wife can seek separate residence and maintenance from her husband. So, before this act, Section 2 of the Hindu Married Women's Right to Separate Maintenance and Residence Act 1946 entitled a Hindu wife to claim separate residence without forfeiting her claim for maintenance. Section 18, Clause 2 of the Hindu Adoption and Maintenance Act now incorporates the same grounds by repealing the Act of 1946. In the present Hindu Adoption and Maintenance Act of 1956, these grounds that provide for separate residence and maintenance are as follows. So, firstly, if he is guilty of desertion, so that means abandoning her without reasonable cause and without her consent, against her wishes or willfully neglecting her. Secondly, if he has treated her with such cruelty as to cause a reasonable apprehension in her mind that it will be harmful or injurious to live with her husband. Next point is if he is suffering from virulent form of leprosy. Next is if he has any other wife living. Next point is if he keeps a concubine in the same house in which his wife is living or habitually resides with the concubine elsewhere. Next is if he has converted to another religion, he has ceased to be a Hindu. And next is if there is any other reason that justifies her living separately. So now let's discuss these clauses where a woman can claim separate residence one by one. Wife is entitled to live separately from her husband and claim maintenance if the husband is guilty of desertion, which is defined as abandoning her without reasonable cause, without her consent, against her wishes, or willfully neglecting her. In Section 13, Clause 1 of the Hindu Marriage Act 1955, desertion is defined as one who has not resumed cohabitation for a period of 2 years or more after the passing of decree for judicial separation against that party. Thus, if two spouses have been living separately due to the conduct of the other, it is considered as desertion. However, if two spouses live in different places due to their employment, it doesn't amount to desertion. In most cases, the existing circumstances determine the decision. The desertion is a ground for divorce as well as judicial separation under the Hindu Marriage Act. Under the matrimonial law, desertion is more of a mental act than a physical act. In its essence, desertion is a total repudiation of marriage obligation or an abandonment of the deserted spouse with the intention of bringing the cohabitation to an end. Furthermore, in order to establish desertion, the deserting spouse must prove two things simultaneously. Firstly, the factum of separation, and secondly, the intention to desert. Many cases also involve the observation of constructive desertion. The term constructive desertion is used to indicate that the spouse who compels the other to leave is guilty of desertion, even if it is the other party who physically departs from the matrimonial home. Furthermore, in a full bench judgment of the Kerala High Court titled Raghavan Radhakrishnan versus Satyabhama Jayakumari, adopting a sociological approach towards the dimensions of desertion, held at the point where the husband is guilty of desertion, it is sufficient to prove that he is living separately, and there is no need to prove intention. This provision aims to assist a Hindu wife. According to social justice, a wife living separately to claim maintenance under this section must prove only desertion by her husband. It is not necessary for her to prove the intention to desert. When a wife converts to another religion or leads an immoral life, she forfeits her right to separate residence and maintenance. So now let's discuss subclause B about cruelty. Hindus treat marriage as a sacred union between husband and wife. The husband may unintentionally cause mental cruelty in marriage without any physical injury, extending beyond mere physical torture. Generally, to determine cruelty on the part of the husband, the courts are of the opinion that the conduct of the husband should be more serious than the ordinary wear and tear of the married life. Before reaching a conclusion, one must examine the cumulative effect of the conduct, considering the circumstances and background of the parties. No reasonable wife should tolerate such conduct, nor should she be expected to endure it. The mere drinking habit of the husband is not sufficient cause to sustain a claim of maintenance in the absence of evidence of ill treatment or conduct that amounts to cruelty on the part of the husband, as decided in the case of Shobha De versus Bhima, AIR 1975, Odisha 180. It is a basis for the wife to live separately and claim maintenance is cruelty on the part of the husband so as to cause reasonable apprehension in the wife's mind that it would be harmful or injurious to live with him. It is also a ground for divorce under judicial separation under the Hindu Marriage Act as defined under Section 13 Clause 1 Subclause 1A and Section 10 of the Hindu Marriage Act. Whether a particular act constitutes a cruelty or not is determined by variety of factors. According to the clause, the legal concept of cruelty consists of two elements that the wife must prove. She has to first prove the ill treatment complained of, and secondly, she has to prove the result and danger of apprehension. as decided in the case of Venkataramaiah versus Mahalakshma, AIR 1966, AP 289. In another case, Anubha versus Vikas Agrawal, AIR 2003, the husband harassed, beat, shouted at and mentally and physically tortured the wife for dowry. Her husband did not allow her to telephone her parents unless he was present, and he levied unfounded allegations of unchastity against her wife. Under this act, the wife is entitled to relief. The husband's mere drinking habit here is not sufficient to support the claim in the absence of evidence of ill treatment or cruelty. The conduct of the husband will amount to cruelty when he is accused of being barren and has not undergone any medical test to prove his virility, capable of fathering a child. A virulent form of leprosy is the third ground on which wife can claim relief. So, referring to the meaning given to it under Hindu law, one can interpret the term virulent, which is not a medical term. Leprosy is considered to be such a dangerous disease that it adversely affects even marital relations. The term leprosy is generally interpreted as malignant or infectious. Section 10, Clause 1 of the Hindu Marriage Act 1955 grants either party to a marriage the right to seek judicial separation, while Section 13, Clause 1, Subclause 4 of the same Act grants either party the right to seek divorce if the other spouse is suffering from a virulent form of leprosy. However, the distinguishing factor between these two acts is that for the purpose of judicial separation, the wife has to prove that the husband's illness is leading to a detriment to her life. But such a thing is not necessary for the purposes of this Act. There is no specified limitation period in this Act for the wife to claim separate residence. However, it is commonly stated that once she becomes aware of her husband's disability, the main reason for including this ground in this Act is dangerous nature of the disease. It can be contracted by anyone in the constant contact with the patient, thereby automatically justifying the right to separate residence. The same is also a basis for divorce under Section 13 of the Hindu Marriage Act. So, dear friends, let's now discuss the Clause D, which talks about having another wife. To old Hindu law, if the husband had taken another wife, the first wife was not entitled to leave his house as long as the husband was willing to keep her there. However, after the passing of the Hindu Adoption and Maintenance Act 1956, if the husband has taken a second wife, she is entitled to claim maintenance against the husband. The courts have interpreted the term any other wife living in quite a variety of ways. The word living does not mean living in the same house as the husband. The fact that the wife is alive would give rise to a cause of action on the part of the second wife to claim maintenance. If the wife refuses to live with her husband on the ground that he has kept another wife, that would not constitute desertion by the wife, and hence it would not bring her right to maintenance to an end under this section. Also, if the wife is living separately from her husband because her husband has married another wife, she in that case can live separately and would not forfeit her right to maintenance. Let's now discuss Clause E, in which the wife is entitled to claim the relief if the husband keeps a concubine in the same house in which she is living or habitually resides with the concubine elsewhere. Section, in order to claim maintenance and the right to separate residence, it is necessary to prove the fact that the wife and the concubine are living in the same matrimonial home. The court in the case of Bansidhar versus Joshna Rani, AIR 2002, Odisha 182, considered factors such as husband's conduct within a defined period, his mental attitude towards frequent visits to the concubine, his statements, and his relation to that lady to determine his usual cohabitation with the concubine. Moving on, if the husband has converted to another religion or if he has ceased to be a Hindu, he still has to maintain his wife and provide a separate residence for her. Simply ceasing to be a Hindu would not absolve the husband of his responsibility to maintain his wife. However, subsection 3 of section 18 removes the wife's right to claim maintenance under this act if she ceases to be a Hindu by conversion to another religion. If the husband ceases to be a Hindu, the wife is entitled to separate residence and her claim for maintenance. It is the time to discuss the last clause now, which is the residuary clause, and how it provides for cause that is justifiable but not covered in any of the above 6 clauses which we discussed. For example, the husband's behavior is blameworthy, although it does not amount to cruelty or desertion. But a mere difference of opinion between the parties cannot amount to a justifiable cause. The husband sold the house without the wife's consent and knowledge and claimed the purchaser took possession by illegally keeping the wife in a mental asylum. In the case of Meera versus Sukumar, AIR 1994, Madras 168, the court held the husband's conduct to be blameworthy, entitling the wife to claim relief under this clause. This clause also covers the situations where the husband's conduct makes the wife's residence in his home miserable. These statutory provisions allow the wife to live separately without forfeiting her claim for maintenance during her husband's lifetime, provided that the woman can claim this right only as a wife and not as a widow. The words Hindu wife used in section 18 include only a lawful wife or legally wedded wife, if they do not include a wife married during the subsistence of the first marriage. Under subsection 3 of section 18, the wife is not entitled to separate residence and maintenance when she converts to another religion or become unchaste. The next 2 grounds have evolved from the judicial pronouncements, such as when she resides separately without any reasonable justification, or when the wife lives separately as a result of compromise and waives her right of maintenance, as decided in the case of Meenu Chopra versus Deepak Chopra, AIR 2002, Delhi 131. The husband's conduct must be grave and weighty to justify living separately, and what may annoy or be resented by the wife does not qualify as a reasonable cause. The conduct should be such that it renders cohabitation virtually unendurable. The court must determine the root cause and the genesis of the problem that ultimately led to their separation and apply judicial reasoning to resolve this crucial question. So with this, we come to an end of today's lecture. Thank you very much.